State versus Thomas Galluzzo, 16305. Controlled substances, drug paraphernalia.
Can I approach, Ryan?
You may approach.
I have standing permission to approach today for
Yes,
these
sir.
applications.
Indeed.
Thank you.
Sir, I've appointed the Public Defender's Office to represent you. I don't see that he's been arraigned. Has he been arraigned?
I don't believe
Is this
so.
your first appearance?
No, this is my second.
Okay, let me look here.
He was arraigned on the 22nd, Your Honor.
Okay. All right. So we've appointed the Public Defender to represent you. Let me see when your next appearance is. December 1st at 10 o'clock. Make an appointment to see the Public Defender.
Yes, sir.
Thank you. State versus Jacob Shipman, 16130. Instruments of crime, controlled substance, criminal mischief, commercial burglary. Mr. Shipman, I'm looking at a police statement. Have you gone over this and these conditions of suspension or probation?
Yes, sir.
Have you signed both of these?
Yes, sir.
Do you feel you understand what's set out in these documents?
Yes, sir.
Do you understand the charges against you and the range of penalties if you're convicted?
Yes, sir.
Are you pleading guilty to commercial burglary, criminal mischief in the second degree, possession of marijuana, and possession of an instrument of crime?
Yes, sir.
But entering these pleas, you give up your right to have a trial and you do not get to appeal. Do you understand that?
Yes, sir.
Are you entering the plea freely and voluntarily?
Yes, sir.
Have you been promised anything other than this sentencing recommendation?
No, sir.
Have you been pressured or threatened to get you to change your plea?
No, sir.
And are you pleading guilty because you're in fact guilty of these crimes?
Yes, sir.
On or about April 27th here in Baxter County, did you enter into the Dollar Tree? I guess, did you break into the Dollar Tree store?
Yes, sir.
Okay. And when you were stopped, you had some marijuana on your person, is that right?
Yes, sir.
This time, sir, I accept your plea. For the commercial burglary, I'm going to place you on 3 years probation with criminal mischief, 90 days for the, is it a 1-day sentence for the marijuana, is that right?
Yes.
Okay, and as it is for the possession of an instrument of crime. You ordered to pay $200 in costs, a $1,000 fine, a DNA fee of $250, a $20 booking fee, a drug crime assessment of $125. Pay what you owe at the minimum rate of $100 per month, beginning, it says within 60 days. Is that what? Okay. Make your payments to the Sheriff's Department here in Baxter County.
And I will be paying that in full as soon as the file's set up at the sheriff's office.
Very good.
We'd like to get on the record that that was under the terms of Act 346.
That is correct, Your Honor.
It was under Act 346, yes.
You know, that completes my business, if I may be excused.
Indeed, thank you. 16-93, State versus Jeremiah Selfridge, rape, incest. Has he been examined yet? He has. Did you know if we got a report back? We didn't.
Judge, this is a brand new case to me. Mr. Selfridge, I went to see him at the jail last week, or Monday, and he bonded out. So we haven't had a chance to meet yet.
Okay.
Of course, I'll need plenty of time to prepare this type of case, so I'm not sure what the exact dates are as far as scheduling orders go, but we'll need time.
Okay.
He's set for trial next week, Your Honor.
Obviously won't be ready for that, Judge.
No, act accordingly.
Will do.
Okay. State versus Nicky Blow, theft of property. You'll note the trial date.
Yes, Your Honor, I've spoken with the state about continuing this matter, and I don't believe there's an objection from them. We will take the time, obviously. It'll be at our request.
Here you go. State versus Danielle Wilkinson, 1622.
She doesn't have a case to you, Your Honor.
Okay. And 1621. These are, at least one of them's unlawful use of communication device and drug cases, basically.
Judge, we've had some meaningful talks regarding resolution of these matters. Unfortunately, we don't have it completely resolved, so if you'll leave it as scheduled, we should be able to report to the court a resolution before the trial.
So be it. Free to go.